Hello, students. Today I will lecture on Chapter 4, Common Law, Statutory Law, and Administrative Law. We talked about common law last week in Chapter 1. Common law is the sum total of all cases decided by appellate courts. The common law of North Carolina is all cases decided by North Carolina appellate courts. Common law predominates in tort law, contract law, agency law, and it's also important in property and employment law, all encompassed in this business law course. Stare decisis is a Latin term meaning let the decision stand, and it means the rulings from previous cases must be followed for predictability or precedent, which means that if an appellate court has decided a particular issue, it will apply the same standard in similar cases in the future moving forward. The text talks about bystander cases, bystander law, and today some states have passed bystander statutes requiring a bystander to help somebody in need. Bystander obligations in the past were that individuals have no duty to assist somebody in peril unless you create the danger. And it starts off talking about that Union Pacific Railroad Company case in 1903, which shows that bystanders have no duty to help. Then Carey versus Davis, which was an Iowa decision in 1921, the court created an exception to the bystander rule, carving out the exception that a bystander can be liable for not helping if he or she was the employer, the worker was suddenly stricken, it was an emergency, and the employer was present. Then, in 1976, the date is incorrect in the PowerPoint. It said 1906, but in 1976, you'll see in the Tarasoff versus Regents of University of California case in 1976, the court creates a further exception to the bystander rule and says there is a duty to help if there's a special relationship between the parties, and in this case there was a therapist-patient relationship. And you can read that case along with the Seinfeld example in the text, along with the exam strategy at the top of page 87. Statutory law is law created by the legislature or Congress. According to the text, 10 states have a duty to rescue statute, which is protected under criminal law, requiring bystanders to help a person in danger. These are laws passed by the legislature requiring witnesses to report the crime that they witness if they can do so without endangering themselves or others. There are examples of discrimination laws, which are statutory law passed by Congress, and the text gives examples of laws enacted during the civil rights movement in the 50s and 60s. The Civil Rights Act of 1964 is discussed in the text to show, well, first, changes in our society leading to the passing of new laws. And it also shows how laws are deliberated and passed, and shows how long that bill took to pass through Congress. It took so long that it spanned different presidential terms. The text also talks about statutory interpretation. How do courts interpret what a statute means? And courts interpret statutes based on the specific facts of a case brought before it by, one, the plain meaning rule. They'll just look at the ordinary meaning of the language and apply that. Two, they'll look at the legislative history or intent of Congress passing the statute, and if the statute language is unclear, then the courts look to the records of deliberation of the legislature to see what legislators meant when they passed the law. Why? And then the third thing courts look to interpret statutes would be public policy. If the legislative history is unclear, they look to prior court decisions to see what is best in the public interest. The voters' role and congressional override. These are sections on page 95 show how checks and balances work when the public, Congress, and the president disagree with a court decision in a case related to quotas. So what's congressional override? We talked about that last week. When the president vetoes a bill, Congress has a chance to make it a law by the power to override. Remember, 2/3 override if the president vetoes the law. And you can look at the exam strategy on the top of page 95, which discusses the plain meaning rule and how it's applied. So the third topic today is administrative law. Administrative agencies do three things. They make the rules, they conduct investigations, and they adjudicate hearings. Examples of administrative agencies are the IRS, the EPA, the FTC, the FCC, the FAA. So these agencies are usually abbreviated. So the IRS is the Internal Revenue Service. The EPA is the Environmental Protection Agency. The FTC is the Federal Trade Commission. And these are all examples of administrative agencies in our society today. Let's see. Congress does not oversee the day-to-day workings of the industry. That's the job of administrative agencies. Okay, courts decide individual cases. They don't regulate agencies. That's what the administrative agencies are for, to regulate specific industry. So the duties of administrative agencies are to regulate, investigate, and to punish. And they are both on a federal and state level. And most of the professions we know are regulated by administrative agencies, right? Accountants, lawyers, electricians, doctors. Some administrative agencies are part of the executive branch, and the president has removal power, and some are independent agencies, and they're outlined in the textbook if you want examples. What are the powers of administrative agencies? Well, first, they're in charge of rulemaking to create fairness and uniformity, and they legislate their legislative rules and interpretive rules. And the two methods of rulemaking are, one, their informal rulemaking by notice and comment. They publish their proposals, and the public has a comment period where they can give feedback. And two, they have formal rulemaking by holding a hearing with the public after a fact-finding mission. And there are examples in the texts, and there's a question board there's a homework on the discussion board as an example of an administrative agency. So how do agencies conduct investigations? They issue subpoenas. A subpoena is an order to appear at a particular time and place to provide evidence. Judges in cases issue subpoenas, and in this case, administrative agencies issue subpoenas to get information and records and testimony. Limits on agency investigation include the following. They must be relevant to the investigation, not unreasonably burdensome, and must not be privileged information. So those are the limits on investigations by agencies. For example, the scope of a subpoena, they can subpoena records that are relevant to the specific investigation, meaning they can't say, oh, we want copies of every record in your entire office. They just want something. They can just subpoena records specific to the issue at hand. Search and seizure, they can show up unannounced and inspect and take documents. And any of you who work in industries where OSHA is an administrative agency that regulates or investigates, you'll know that OSHA can show up in the workplace at any time. And they also adjudicate. They conduct formal hearings before an administrative law judge. Okay, that's a summary of Chapter 4. If you have any questions, feel free to email me, but the information will be more comprehensive in the text if you read Chapter 4, and I'm happy to answer any questions you have. Please tune in for our weekly meeting virtually. Thank you.